Welcome. Today, I'll be explaining what CFIUS is and the top 3 legal issues U.S. companies need to understand if they're considering a foreign investor or buyer. My name is Brandon Sun, and I'm with the Clark-Esposito law firm PC. CFIUS stands for Committee on Foreign Investment in the United States. It's a U.S. government committee authorized to review certain transactions involving foreign investment in U.S. businesses to determine whether they pose a risk to U.S. national security. If your company is bringing on a foreign investor, selling a stake in the business to a foreign company, or considering a foreign acquisition, your transaction may trigger a CFIUS filing, even if a national security issue does not seem obvious at first glance. Here are the top 3 legal issues U.S. companies should know. First, what transactions trigger CFIUS jurisdiction? CFIUS does not only review full acquisitions. It can also review minority investments if the foreign party receives certain rights, including access to non-public technical information, board seats, or decision-making authority. CFIUS jurisdiction is especially likely if the U.S. business is involved in critical technologies, critical infrastructure, or sensitive personal data. Even early-stage companies and routine capital raises can trigger a review depending on how the deal is structured. This is where legal counsel matters. Small drafting decisions in investment documents, such as including a condition that your filing passes CFIUS review, can be the difference between a transaction that proceeds smoothly and one that unexpectedly triggers government review. Second, mandatory filings and timing risk. Some transactions require a mandatory CFIUS filing, meaning the deal cannot legally close until the filing is submitted and cleared. Missing a mandatory filing can lead to civil penalties, forced mitigation, or government scrutiny after the deal has already closed. CFIUS timing can directly affect deal schedules, investor expectations, and closing conditions. Identifying whether a filing is mandatory or strategically advisable early in the process helps companies avoid delays, renegotiations, and enforcement exposure. An attorney experienced with CFIUS can flag these issues before they disrupt the transaction and ensure that the filing process and the corresponding Q&A with CFIUS that inevitably happens proceeds effectively. Third, CFIUS mitigation and post-closing obligations. Even when a transaction is approved, CFIUS may impose mitigation measures. These can include restrictions on data access, limits on governance rights, reporting obligations, or compliance requirements that last years after closing. For U.S. companies, these obligations can affect daily operations, management decisions, future investments, and exit strategies. Understanding this allows companies to better manage expectations on all sides, and trusted counsel can help you understand what these could be. For companies with foreign investors or buyers, CFIUS is not just a deal issue, it's a business issue. How the transaction is structured, how risks are assessed, and how the government is engaged can determine whether the deal moves forward efficiently or becomes a long-term compliance burden. The Clark-Esposito law firm PC works with U.S. companies to assess CFIUS risk, determine whether a filing is required, coordinate with counsel for the foreign investor, and guide clients through the review process with a focus on protecting business operations and long-term goals. You can schedule a complimentary intake meeting using the link in the description or contact us at 917-546-6997 or contact@clarkespositolaw.com. When foreign investment raises government questions, preparation makes all the difference.
Subscribe and click the bell icon so you'll be the first to know when we upload a new video. Check out our playlist if you want to see more of our videos, and comment below and introduce yourself. We'll see you soon.